Hi, everyone watching us from online. Just let you know, we'll start in 5 minutes time. Stay closer. Okay. Good afternoon, everyone, and welcome to another Hong Kong IARB seminar. So I'm your host today. I'm Anthony Tong, council member. Today we have the great privilege of having Dr. Benny Loh here with us to talk about a very, very interesting topic on introduction to sports arbitration. As much as the fact that this may not be something that we do in day out, Benny will talk about all kinds of sports, a lot of sports, football, basketball, swimming, everything else, with a lot of notable cases. So it will be a very entertaining and informative session. So a very brief introduction of Dr. Loh. He graduated from Cambridge University in 2006 with first in contract equity and land. He is a barrister, of course. He focuses on civil commercial company IP dispute resolution. And apart from acting as advocate, Dr. Loh also regularly sits as an arbitrator. He has a long list of arbitration accreditation: Hong Kong IAC, SIAC, CTAC, BAC, SIA, SHIAC, SCIA, etc. WIPO, or including, of course, FIBA, the Basketball Arbitration Tribunal. He has received over 95 arbitral appointments. He has done quite a few important cases, including one that he mentioned about Jin Hae-seo against the Republic of Korea, a property expropriation dispute brought under the US-Korea Free Trade Agreement. He is also one of the 9 arbitrators appointed to the Basketball Arbitral Tribunal, set up under the statutes of FIB in Geneva, Switzerland. So without further ado, I will hand the floor, the stage to Dr. Loh. Dr. Loh, thank you very much.
Thank you very much, Anthony, and also to the Institute for inviting me today to give this introduction talk to sports arbitration. Now, I'm certainly by no means an expert, and I think probably the only reason why I'm invited today is because I do too much arbitration but too little sports. And I'm sure it is well intentioned by Anthony that I should do more exercise in addition to talking about sports arbitration. Now, today's purpose is really for me to give you some personal sharing of what I know, how I came to be involved in sports arbitration about 3 years ago when I joined the arbitration tribunal in basketball set up by FIBA some years ago. Really is to improve awareness of this subject and also to let our legal community really learn about what opportunities there might be for us, whether as counsel, as arbitrator, or as policymaker as well. As in Hong Kong, at least as far as I'm aware, we are setting up, the different professions are setting up organizations to push and to develop our community into one that is ready for sport arbitration. And we actually have plans to set up some form of institution or set up some kind of rules for our own sports arbitration. So watch this space. I hope that this is an informative talk for you. Now, our sports arbitration is really a vast subject. So I've selected a few topics to share with you today, this evening. I will first very briefly talk about what is sport arbitration and, of course, the sports arbitral institutions involved. I will then, as Anthony foreshadowed, take you through some of the very notable cases. Basically, you see them all reported online, and I'll highlight some of them. I will then highlight the differences between sports arbitration and perhaps more familiar to most of us, commercial arbitrations, and what are the major points of difference. For enforcement is, of course, a big thing for any kind of arbitration, and no difference for sports arbitration. And I will then highlight the differences and what are the peculiar features of enforcement in sports arbitration awards. And then closer to home, I will wrap up the talk by briefly talk about sports arbitration in China and Hong Kong. Now, what is sports arbitration? Of course, arbitration is a form of alternative dispute resolution, and we all know that. And the contrast, of course, is court litigation. And the common topics in which they are arbitrated in terms of sports really fall into 2 categories. One is regulatory/disciplinary. We'll see in the box on the left, sports regulatory issues in terms of selection selection, disqualification, transfer, and then more technical areas such as doping, and also other disciplinary or integrity issues. All of those can be subject of arbitration. Now, on the other hand, there will also be, in sport is big money. Let's make no mistake about that. There will be a lot of, there are a lot of commercial disputes in the context of sports, involving IP, media rights, employment, agency sponsorship, even competition. So these are also arbitrable subject matters. Now, the disputes themselves, of course, will then give rise even to bigger and broader legal implications beyond the actual case in issue. It might, for example, give rise to implications such as breach of contract by an athlete or a player, then with the sponsor due to certain doping allegations, which might then becomes proved after certain doping proceedings. There may also be some implications on criminal liability, such as assault or other kinds of match fixing, for example. So why is why is it timely and why is it important for us to talk about sport arbitration? Now, as I've already mentioned, there is a huge market for it. Now, if we look at the chart on the left, what I've tried to set out here for you is really some data from a very recent April 2023 report called Sports Global Market Report 2023, which really give you the statistics of the size of the market in question and project and forecast how big this market will become. If you can see, look at the column for 2023, this global sports market is worth 512 billion US, and that will rise 20% to 623 in 2027, 4 years time. So really, the sports market is huge, and to a large part is dominated by spectator sports, and also to a large part is the US, which really take up quite a large share of this pie. So it is a huge market involving lots of different kind of revenue for the relevant stakeholders, the media rights, selling tickets, merchandise, advertising, and sponsorship. So all of that are really ripe grounds for dispute to happen, and therefore we need a good system to resolve them. Now, there are certain unique features of sport on the right hand side. You can see a list that really makes such disputes suitable for arbitration instead of traditional court litigation. Short careers of sportsmen, speedy, tight schedule of sporting events, and also necessity for finality and also integrity of this sporting result, all in a very short time frame. So speed and finality are really the two distinguishing features why sports disputes are so suitable for arbitration instead of going to the courts. Now, of course, no presentation of any sport arbitration topic will be complete without introduction about the institutions involved in administering these arbitrations in terms of sports. Now, of course, the Court of Arbitration for Sports is really the premier arbitration institution in question. It has been described as the Supreme Court in the world of sports. There will also be a few other institutions I'll briefly mention. Now, I think it would be useful for me to take you through the very broad arbitration process. So you have on the left, there's a dispute that arises, and the parties may then attempt to go through a slightly less formal form of dispute resolution process, such as mediation. If mediation succeeds, then of course the result gets settled into a binding agreement or some kind of final decision. But if not, then it then goes to a slightly more formal process of dispute resolution. Now, very often in sports, in the sporting organization, the concerns such as the local federation or the club or even some kind of association, they will have their own in-house dispute resolution mechanism. So we don't need to go to Court of Arbitration Sport in the first instance. You will get resolved the dispute there and there. Of course, then these mechanisms are not independent. They very often will involve dispute between a certain player with that particular organization itself. So it is not necessarily viewed as an independent way of resolution. CAS will have its own original proceedings as well. So we will call them the CAS ordinary proceedings, such as what we often call them as first instance trial. So there's a dispute, you go for first instance trial. Why do I talk about first instance? Is because for CAS, there is actually appeal procedure. So if a party is not satisfied with the original ordinary proceedings or the decision of a sporting organization, they can take the case on appeal. Now, very often in commercial arbitration, you don't have such an appeal procedure. Very often for commercial arbitration is final, subject to a very limited ground of challenge of the award. You don't get what is called a formal appeal. But in sports arbitration, appeals are very, very common. Very, very common. In fact, for CAS arbitration, most of it, as I'll show you, in fact, over 90% of the cases are appellate proceedings. Now, going to the genesis of Court of Arbitration for Sports, it was established in 1984 by the International Olympic Committee, IOC. It is an independent institution in Lausanne, Switzerland, that settles sports-related disputes by arbitration and mediation. It was overseen and is overseen by the International Council for Arbitration for Sports. And really, the purpose is to take the resolution of dispute out of the hands of national courts, which are often slow and lack specialized sporting knowledge. It actually puts together a whole body of expertise and also a list of specialist sports arbitrators that are very familiar in resolving disputes in the world of sports. Now, I've already foreshadowed that there are two divisions in CAS. One is the first instance tribunal called the CAS Ordinary Division. And you'll see that it is, in the second bullet point, it's party-driven or designated by sports institution internal regulation. So what this means is that when a dispute arises, or in their party's contract, there may be a provision for arbitration in terms of disputes, and then it will specify that any dispute arisen will be referred to the CAS Ordinary Division for resolution. Alternatively, in the sports institution's internal regulation, they may have similar provisions to say that if there's a dispute, if that organization does not have its in-house resolution procedure, it may specify that the dispute can go to CAS Ordinary Division. So we will just go along with the CAS procedure rules and get resolved. So, but as I say, this is really the minority of cases dealt with by CAS. The majority of cases are the appellate proceedings. And these appeals on the right-hand side, you'll see are against decisions by the sporting institutions or other prior CAS Ordinary Division decisions. But however, it is important to note that these appeals must be provided for under the relevant regulations of the institutions or in the arbitration agreement itself. So in the cases that I deal with for the basketball arbitral tribunal, they will often say that the dispute gets resolved by us, first of all, and if any party is not satisfied with the result, then they can go to CAS for an appellate ruling after the award is rendered by us. So, it needs to be specifically provided for before you can go to appeal before CAS, unlike the Court of Appeal we have in any courts, in the domestic courts. So this is the statistic. All cases from CAS, really most of them are, among all the cases, among most of them, 90% relate to appeal procedures, and only very little go to ordinary procedure. Now, CAS has presence all over the world in terms of administration. It is headquartered in Switzerland, in Lausanne, but it has other hearing centers, offices as well. As you may or may not have heard, CAS also will set up its ad hoc tribunals with the Olympic Games. So, for example, for the last Olympic Games in Tokyo, before the games started, the CAS will actually set up a body of 10 arbitrators who will then be in Japan to be ready to deal with any particular disputes arising out of the gates. I'll talk a bit more about that later. So it is really a body that is really all over the world. It's well recognized in the world of sports. Now, in terms of the code or the regulation or the rules, procedural rules for CAS proceedings, it is called the Code of Sport-Related Arbitration and Mediation Rules, CAS Code. The particular provisions that are important for the procedure itself is rules 27 to 70, which give the general provisions, and also it talks about, in section B, it talks about the ordinary arbitration procedure. That is the first instance procedure as talked about, and then there will be another section C dealing with the appellate proceedings. Now, what kind of cases does the CAS hear? It really is a very broad term known as sports-related dispute. Anything that is directly or indirectly related can go to CAS. And I've provided here some important points. If, for example, it involves commercial dispute, sponsorship dispute, media rights, transfer regulations, employment issues. Number 3, there are sports-specific dispute, doping is a big thing. Eligibility, accident or incident on the field. It's important to note that actually in what we call sports law actually amalgamate many areas of law, including personality right, and that is like IP, more IP-like, association company law, contract law, tort law, company law as well. Now, as to whether a particular dispute is arbitrable by CAS, it is something that the CAS will have its own power to decide. But given the very broad definition, I think that is not a huge problem. Not a huge problem, so long as it is directly or indirectly linked to sports. Now, in terms of seat of arbitration, now for all of those of us who are familiar with arbitration, the seat is very important because it determines under which jurisdiction is the arbitration supervised in terms of their courts. If anything goes wrong about the procedure or the award, which court you go to challenge the award. So that is called the seat, or sometimes called the place of arbitration. So in terms of the CAS proceedings, by default, all the cases are seated in Lausanne, and therefore it's a Swiss arbitration essentially. So therefore, the arbitration law that lex arbitra is Swiss law, and if you want to challenge the award, you go to what we call the Swiss Federal Tribunal. So it's a division of the court in Switzerland dealing with setting aside not only of CAS awards but also other awards seated in Switzerland. BAT awards, the Basketball Arbitral Tribunal Award, are seated in Geneva. They also go to the SFT, Swiss Federal Tribunal. Now, having dealt with the seat, then you might ask, what is the applicable law? Now, and there is a difference between the ordinary CAS procedure and also the appeals arbitration procedure. Now, for ordinary procedure, parties are free, essentially, to choose what law that govern the dispute, either it's in the contract or in the internal regulations of the relevant sporting body. On the right here, you will see that it can be either national law, transnational law, general principles of law, merchant law, or even ex aequo e bono. Now, this term may be familiar to some of you. What it means in English is that according to right and good. So not by reference to any particular domestic law, we just based on good conscience and fairness to rule a case. So in Hong Kong, in fact, the concept of ex aequo e bono, and also in other ancestral model law jurisdictions, is actually laid down in the statute. In Hong Kong, is Section 64 of the Arbitration Ordinance, adopting Article 28 of the ancestral law that permits ex aequo e bono to be adopted if the parties authorize the arbitrator to do so. So this is the ordinary procedure, which parties' freedom are really has quite a lot of freedom to choose the substantive law. Yeah. Oh, sorry. Oh, I'm sorry. Okay, it's better now. Thanks. Now for the appeal procedure, it's slightly different because of course, as I said earlier, the appeals must be provided for in the regulations themselves or the arbitration agreement itself. So the tribunal will first apply the relevant regulations of the sports body if it is an appeal from a decision of a sporting body, and subsidiarily the party's own choice of the law. For example, if it's a contract, and the tribunal, the CAS appeals body, will apply that law. Now, but if the parties have not made such a choice, then arbitral tribunal can decide according to the law of the country where the sporting body is domiciled. So all of this is actually provided for in the rules. Now, I've also mentioned this ad hoc division of CAS, which goes to the Olympic Games, essentially. Now, just to give you a bit of background, the Olympic Charter under Rule 61.2 actually requires that all the dispute during the Olympic Games and in relation to the Olympic Games shall be submitted exclusively to CAS for resolution. And therefore, CAS has since 1996 been setting up these ad hoc divisions at each Olympic Games, and these disputes are heard by 3 arbitrators. Now, as I've mentioned before the Tokyo Olympics in 2020, there were 10 CAS arbitrators that were assigned to this division for Tokyo Games, and they actually had to go there. And in Tokyo, there was including 1 arbitrator from China. So, in terms of statistics, following the games, about 9 decisions were published as a result of dispute referred to the ad hoc division. So this is really the scale of the problem, and it enables timely decision on the dispute to be resolved right there at the site of the Olympic Games. So that is really the beauty of it. Now, apart from CAS, there are also other institutions with their own system of dispute resolution. I've included here 2 examples. For football, for FIFA, there is something called the FIFA Tribunal, Football Tribunal, FIFA Football Tribunal, and one of which is the Dispute Resolution Chamber. There are actually 3 parts of it. The main part is the Dispute Resolution Chamber. There are also these other parts called the Player Status Chamber and also the Agents Chamber, resolving different types of disputes. So you will see that for the DRC, Dispute Resolution Chamber, it consists of 24 permanent judges appointed by the FIFA board. So that really, again, illustrates that the specialist nature of sport arbitration. These 24 permanent judges are arbitrators. They call them judges. They're arbitrators. Really are specialists and are coming from a closed list of arbitrators. So unlike in commercial cases, commercial arbitration, where parties are always free to choose whoever they want, in sports, very often you are only limited to choosing from a closed list. Closed list is one distinguishing feature of sports arbitration, as I will come to later. For the basketball arbitral tribunal BAT set up by the International Basketball Federation under their statutes, it is an independent tribunal resolving disputes between players, agents, and clubs, seated in Geneva. It is normally, and in the vast in the vast type of cases, resolved in English. So it is an easy to use procedure. And as I will illustrate later, these BAT cases are governed, not so much governed, but I think it authorizes the arbitrator to apply the notion of ex eo cui bono, which I explained earlier to you. So again, that further breaks down the barrier for parties from different jurisdictions to argue their cases. They are not bound to a particular Swiss law, French law, or Chinese law, Hong Kong law, whatever. But really, parties can apply their arguments to notions of ex eo cui bono, and which are is the principle to be applied by the arbitrators. I'm not going to, because of time, I'm not going to go through the remaining bodies, but I'll lay them down there for your attention. In different countries, there may also be different national sports dispute resolution bodies for sports disputes. Now, the next section, I've set out here some notable cases. I've got 4 of them. Now, the first one comes from is a financial fair play case. Now, for those of you who might not be familiar with what financial fair play is, it really is a set of rules that make sure that, you might find it strange, but it makes sure that clubs do not spend more than what they earn in terms of the investment in their players and other things. So really, they don't want the clubs to turn into financial perils so as to threaten their own existence. So this is a kind of very peculiar set of rules. I mean, it's not entirely uncontroversial. You will see by just Googling the term financial fair play, you will see a lot of things being debated over it. But anyway, this case arose from Manchester City's allegations of it breaking financial fair play rules. Now, of course, you can always jiggle around and play around with it by inflating and overstating your revenue, or you hide some of the expenditures, and therefore you try to strike that balance. But then, of course, that it involves wrongdoing. Now, this is the case in which Manchester City was alleged as having overstated its sponsorship revenue by a huge amount of money, 204 million pounds. And the first instance decision was made by UEFA. You see that it imposed 2-season ban of the club from European competition and fined quite a large amount of money. Now, that illustrates the appeal process to CAS, because Manchester City then initiated an appeal arbitration against UEFA's decision to CAS. And what happened after the CAS appeal procedure? Man City won. So it is a majority ruling by the CAS panel. The ban was overturned, and the fine was reduced, quite a large amount, down to 10 million euros. Next case involves a Swiss football club alleged of having encouraged players to break contracts with other clubs. So that is, and the UEFA found this proof and disqualified the club from the Europa League, and also invalidated some of the results, or the relevant results. And of course, the club then appealed to the CAS for a change of the result. But however, that appeal, unlike the Man City case, was unsuccessful. So the CAS panel found that the UEFA was correct to enforce the FIFA regulations and to declare the relevant games as invalid and disqualify the club, and found that the club's action were clear abuse of the procedures, and that relate to the procedural conduct as well. Now, closer to this part of the world, in terms of the next case, Xunyang, of course, I think most, if not all of you, will have heard of this case from several years ago. The case really arose from the alleged refusal of the swimmer, the Chinese swimmer, from providing a sample of the urine, of his urine, and that really was not, if proved, that was not in compliance with the relevant regulations, and we have the WADA regulations governing this kind of situation. Now, FINA was the International Swimming Federation. In fact, initially ruled in favor of the swimmer, but however, the World Anti-Doping Agency appealed against the decision to CAS. Now, CAS imposed a ban. In fact, imposed a very heavy ban on Xunyang of 8 years. And that on its own, really meant practically the end of the sporting life of the swimmer. Now, however, because of a and very unexpected and inappropriate, of course, commentary given by a member of the arbitration tribunal, he made some inappropriate comments on social media, really in the context of criticizing some Chinese people concerning animal welfare. So, of course, it is completely on its own, unrelated to the case in question, but the Swiss Federation, the Supreme Court, in fact, on the basis of that, annulled and cancelled the original CAS award because it held, and I think it was right, that it affected the impartiality of the tribunal in question. And therefore, remitted the case back to CAS for a different panel to then reconsider the case. Now, in 2021, then you might have heard again, the new panel, in fact, found that the breach was proved and imposed a ban as well. But this time, instead of an 8-year ban, it was reduced to 4 years. And 4 years really started counting from 2020, February. So that means that it may not be the end of his sporting career in terms of the Paris Olympic next year. So that is another very notable case. I think many of us will have heard of it. There was, just to run up the cases, list of cases, we have the Russian Olympic doping cases, which really led to the disqualification of Russia from participating in its own name, in the name of the state, in the Olympic Games. And the fact there are several violations of anti-doping breach of these anti-doping regulations found, and the Russian anti-doping agency did not find anything wrong about it, but WADA, the World Anti-Doping Authority, intervened and banned the Russian Federation from participating in the games for 4 years. WADA went to appeal, in fact, against the Russian equivalence decision to CAS, again illustrating CAS appeal procedure, and sought a 4-year period of ineligibility of the state and disqualification of the result. And the outcome from CAS was that there was a 2-year ban imposed against the state, and saying that the Russian athletes can compete, but only under a neutral flag and designation. Now, because of my personal affiliation to BAT, I'd like to say a few words just to do my part in promoting this arbitral tribunal and introducing it to you. Now, the history was that it was established in 2007 under the statutes of FIBA, the International Basketball Federation. Initially, it was called the FIBA Tribunal, but later on, because we want to emphasize the independent nature, we call them the BAT, which is Basketball Arbitration Tribunal. But nevertheless, it is still set up under the statutes of FIBA. So we deal with mainly contractual disputes. So we don't deal with disciplinary dispute or regulatory dispute. We deal with this contractual dispute between players, agents, coaches, and clubs that arise out of their relationships. Now, on its constitution, we can see from Article 16.4 of the BAT rules, transparency is a big thing, not only for BATs, but in fact for sports arbitration in general. And transparency meaning that the awards, at least the awards, are not confidential and they are published. In fact, you can go to Google and type in BAT awards, and that will bring you to a page that shows you that the BAT awards are being published ongoingly, and you can search for particular awards. So awards are not confidential unless ordered otherwise. So that's very different from usual kind of commercial arbitration. CAS awards are also searchable online, so you can search for them in CAS website. Now, since BAT arbitration is seated in Geneva, is under the supervision or under the governance of the Swiss Private International Law Act Pillar, Chapter 12. Now, these are the defining features I've listed there. Why arbitrability is a big thing, and also a very hands-off approach to the review of awards by courts, by the Swiss Federal Tribunal. So that is very similar to our the Hong Kong system or the ancestral system. We try to apply a consistent bodies of general principle of law. Now, even though we go by what we call ex eo quo bono, according to what is right and fair, but we do act consistently. We do try to act consistently, and the way we do that is by we quote our previous decision. Although previous arbitral awards are not binding precedents as such, we will apply certain points that come up again and again consistently in our awards. And I'll tell you, I'll share with you a reason for the way we do it later on. The language is English, as I've explained earlier, and it is very flexible. Ex eo quo bono, that is fairness and equity, speedy. Now we try to issue our awards within 6 weeks, within 6 weeks after close of proceedings, and an average duration from beginning to finish is around just over 6 months, depending on how complicated the case is. And we try to keep the cost down as well. At the moment, we have our cut-off threshold for an award without reasons as being 50,000 euros. Now, if a claim is below 50,000 euros, okay, the default procedure is that an award without reason will be given. Now, and the parties can request for reasons if they then pay extra. So that is, we try to keep the cost down. But for awards about 50,000 euros, then we will issue by default an award with full reasons, as you will see if you go to the website and download some of those awards. Now, I've already highlighted the application of ex eo quo bono in our cases. Pacta sunt servanda, we just meaning that you make the contract, you have to be bound by it, is really the cornerstone of our principle, that we do apply that to our the contractual dispute that we deal with. And also good faith, bona fides, is another one. In the very specific context of basketball dispute, guarantee no cut contracts. Now, that is when you have a contract between a player and a club, usually it's guaranteed. Guarantee meaning that no matter what happened, if you broke your leg or whatever, unless under specific circumstances that is stated, you will get paid. So that is really protect the interests of clients, players, and also prevent negative consequences of early termination. Now, for termination, there has to be what we call a just cause. This kind of term is very much like labor dispute. So just cause termination. And we also have our own jurisprudence on how do you have to approach termination. For example, notice, you have to, you cannot just terminate a contract immediately upon breach by the other party. You need to give a chance for the other side to cure the breach. So by giving a notice, and also you need to look at whether the termination is proportional to the severity of the breach in question. So all of that, we have laid down some case law. These issues tend to come up again and again. And just to give you an idea of the kind of cases we deal with, this case is a very recent case. It's a case between, it's a claim brought by a player, basketball player, against a Russian club, BC Unix, for the 2021-2022 seasons. Of course, on February the 24th of 2022, that was when Russia took military action against Ukraine. And the player left Russia and missed training sessions for fear of his personal safety and that of his family. So therefore, the club used this as a reason to terminate the contract and allege the player had wrongfully left Russia without club's approval. The player then brought a claim before us for outstanding salary and expenses and for compensation for termination without just cause. The particular arbitrator, it was not myself on that occasion, but we looked at, there are actually quite a few number of cases of this nature that arose out of the Russian military conflict, Russia-Ukraine military conflict. And I've dealt with another one, but that one has not been published. But all of these cases, and most of them, in fact, tend to look at in the contract to see whether this kind of military conflict situation fall within the force majeure situations, and whether these situation really made it impossible for the player to render performance, to continue to play and train for the club. This particular case, player's departure was found not to be in breach, and because it fell within that clause, and then the performance was impossible due to the prevailing situation at the relevant time, and therefore the termination by the club was wrongful. Now, earlier I talked about how we try to maintain a consistent body of jurisprudence. Now, of course, one thing that we do is we have on topical issues, we can have under the rules, it's recognized that we are entitled to consult each other. Each other meaning among the arbitrators. We have 9 of us, plus a vice president, plus a president, so 11 of us. We are entitled under the rules to discuss among ourselves on topical issues that affect certain legal or contractual issues that may just have an importance not only for the case in question, but it may also go into other cases. So this particular Russian example I referred to just now was something that we discussed earlier on, not on the slide, but when COVID first came upon us, we actually issued what we call the COVID-19 guidelines in terms of how clubs and players should approach whether there will be any reduction in the payments, having in mind the financial difficulties caused by the COVID-19 resulting in the shutdown and the stopping of the leagues and all of that. But that time has largely gone. Another way, a further way of ensuring developing consistent jurisprudence is that all of our awards, in fact, the draft, are subject to what we call scrutiny. Scrutiny will be done by either the president or the vice president of BAT, and they will draw to our attention any relevant jurisprudence that we have published and for our consideration. Of course, ultimately, much like the ICC system or the CX system, the decision ultimately is on the individual arbitrator. But at least this scrutiny process will help remind us of any relevant jurisprudence that we should try to, upon a principle that unless there's very good reason that we should not really depart from them. So that is another feature of that arbitration. Now, in terms of enforcement, and I think this is also not only true for us, but also for other sporting arbitration bodies. Now, on the right, I will highlight the right box because, of course, our arbitration awards are being seated in Geneva is mainly no different from any other New York Convention arbitration awards. So you can take it and enforce it in any other New York Convention party state for payment orders and so forth. Now, but however, we have something more than that because being a tribunal set up by FIBA under the internal regulations, there is actually a section in FIBA's internal regulations saying that what is the consequence of failure to honor BAT awards. Now, you can impose fines, but I think more importantly, you can actually impose targeted bans on clubs in relation to transfer of players, registration of new players, and participation in international competitions. So these are actually quite effective ways to ensure compliance of awards by clubs. Of course, the same may be slightly less effective on players, but for clubs, this has proven to be very effective. And you don't have to go to take the award to a court, spending all your money, hire your lawyer to enforce it. Now, in the next section of my talk, I'd like to just highlight a few similarities and differences. I think a lot of that have already will have already become apparent from earlier part of my talk. Now, similarities, finality is a thing, of course, subject to the appeal, because the appeal decision will be final. Neutral setting, flexible procedures, and specialized arbitrators. And that really applies also to commercial arbitration cases. Now, differences, there are far more differences. Now, expedited proceedings, I talk about batch, we have 6 weeks decision after the close of proceedings. In fact, for CAS appeal procedures, under the rules, it's 3 months. 3 months is the time limit for rendering of the decisions. For Olympic Games decision, sometimes it needs to be made overnight. The decision is made first, maybe the reasons can come later. Because of the time sensitivity, that is really necessary. Transparency, the third point. I've already highlighted the fact that awards are not confidential unless otherwise ordered. Close list of arbitrators, specialist sport arbitrators, are chosen by the parties or are to be chosen in some cases under the rules of the relevant arbitral institution. Consistent legal seat. Of course, Switzerland is quite a popular one, being the seat for CAS arbitration, also for BAT, and perhaps for some others as well. In sports arbitration, there are a very specialized body of sports law, like Sportiva, and also some under the WADA guides for doping cases. These special rules are special and peculiar only to sports disputes. So one needs really to be very familiar with them if you want to be involved in sports arbitration, especially for disciplinary and regulatory issues. Legal cost. Now, for legal cost is something I haven't really talked about so far, but for batch arbitration, we don't give an indemnity of legal costs. In fact, we only give a contribution. So what we do is, under our rules, which you can look at as well online, we have set out a sliding scale of cases involving different amounts in dispute. And for different amount in dispute, we can only award a certain cap of contribution to legal fees. So parties will not be so afraid of going to batch arbitration because they know that even if they lose, then the exposure is only so little, so much. Okay. The same applies for arbitrators' remuneration, of course. Bad arbitrators don't earn a lot of money. I think, as with many sport arbitrators, we don't. Our current rate is really 350 euros per hour, and there's also, of course, there's also the sliding scale cap as well. So it's really not very much money in it. So, but in the hope that we want to try to make this a popular system, because many players may not have a lot of money, especially if they've been deprived of payment by the clubs. So we want to give them improved access to justice as a quick way and cheap way, really, of getting what they really deserve. So that's really one of the spirits of bad arbitration. Enforcement methods I've already covered, different from and beyond, over and beyond simple New York Convention procedures, and also appeal procedures are also special to sports arbitration. Now, in the next few slides, I've basically given more flesh to this chart of similarities and mostly differences. Unless you have any particular question later, I'm not going to go through them one by one because of time. So I'll skip over to the last section, perhaps, which deals with something closer to home. And I'll start with sport arbitration in mainland China. Now, the important context of this and why we should be interested in this is that China is hosting more major international sporting events, Olympics and other world championships. And there are, of course, with these events, there would be increasing number of disputes related to sport. Sport is big business, and China is no exception. Now, a key date here that I want to illustrate is 1st January 2023. And why is this date important? Is because before this date, there was an existing system of sport arbitration, but it was rarely used. It was not well used. not practical, no lack of practical adoption. Now, but from this stage onward, China has enacted the sport law. There was a fast-tracked revision to sport law, which then led to the establishment of a national organization called Sports Arbitration Commission that governs the arbitration of sports dispute. It has its own detailed arbitration rules on arbitrators' qualifications, composition of the tribunal, procedure, etc. But however, we should note that this is not entirely an independent body because it's supervised by the State Council. In terms of the scope of arbitral disputes, it deals with disputes regarding decisions by sporting institutions, disputes such as those arising from registration and interactions among athletes, and also other disputes as well. It excludes dispute under the traditional, what we call the arbitration law of the PRC. Also, labor disputes are not included in this system. Again, very similarly to other areas of arbitration, awards are final and binding. But of course, there is a you can always go to the supervisory court for any arbitration, and you may petition to the intermediate people's court if there are errors in the application of laws and regulations. So this sounds more like an appeal rather than like a challenge under the New York Convention. So this is finality and bindingness really is to that extent. Now, what about Hong Kong? Now, Hong Kong does not at the moment have anything specific on sports arbitration. But why should we be thinking about it? And why are the professional bodies in Hong Kong thinking about it? Now, Hong Kong has a great potential to be Asia's leading sports arbitration seat. Hong Kong has been doing very well indeed in terms of commercial arbitration already. It's one of the top seats in the world, consistently ranked high by the Queen Mary survey. High quality forum, world-class framework. We are in New York, ancestral model law jurisdiction with a very arbitration-friendly judiciary. We are positioned geographically with high convenience to mainland China and also other Asia-related sport institutions. We have quality lawyers and advocates, and we are accustomed to multilingual proceedings, in particular English. Now, in Hong Kong, the issue is that there's as yet no unified sport-specific rules and law, and I can assure you that effort is now being made towards that direction. I understand that is supported by the Department of Justice and also by the two professional bodies, and we are working with our local sports federations with a view to getting something done. So hopefully we will have something before the too distant future. And of course, e-sport is something that we can particularly look at. It is a substantial and growing industry. In fact, actually, I just learned that children can earn a lot of money from e-sports. So one wonders why they instead of want to spend time reading books, but they want to play games. So it's really surprising, but it is a big and growing industry. There are even talks of adding esports to these Asian Games, and also you look at the sports market at 1.39 billion US in 2022 alone. So there is really a lot of interest in it, but as to the implementation, we really need more interest and also need more support to actually put something in motion. Because for a system to work, we need collaboration and cooperation of not only the institution itself. We need, as I've illustrated, for example, for BAT, we need the International Basketball Federation to write something in their code to do with enforcement, to set it up in the first place, and so that it gains consistency in the decision and also gains trustworthiness by the stakeholders to actually refer dispute to it. So we have a lot of work to do, but I think it's good that we have the interest and we have both professional bodies in support, having sports law committees, both the Law Society and also the Bar Association. We are working towards achieving that goal, hopefully soon. And so watch this space. So I think in light of the time, that concludes my talk. I will try to answer any questions, or even if you have any sharing that you would like to give, then you're more than welcome. So it leaves me to thank the organizers to invite me for the talk this evening. Thank you for your attention.
Turn a little bit. Okay, that's fine. Shouldn't be the center of attention today, so it doesn't matter whether you can see me or not. Anyway, a little bit. So thanks so much, Dr. Low here. So really exciting, as I promised, rich in content. So perhaps I'll start, if I may just ask. You mentioned about the use of HKIArb. How challenging is it for the practicing attorneys representing a client in front of this tribunal? I mean, what was the law? I mean, any law can be the law.
Yeah, thank you. That's a very good question. It was very challenging for me as an arbitrator from the common law world to be get involved in these kind of cases because you don't know what to apply. But as I was saying to you and to all of you, we publish our jurisprudence. We have you can look at different cases to see how we approach, for example, guarantee no cut contract. We have a lot of case law on that.
Right.
We have because these principles are really derived out of the underlying consideration of HKIArb. We don't just apply palm tree justice. We go consistently, but I think when we crystallize or develop these jurisprudence, what we call them, we have HKIArb in mind. So, for example, in many of our awards, you will see that we say that we apply HKIArb, and pacta sunt servanda is one of the main principles of that we abide by. So, therefore, we look at the contract, we interpret the contract in a just and fair way, and therefore apply them to the results. So, it's not hugely difficult. And in fact, I have experience in dealing with, I think, more than 30 or 40 bad cases already. I can tell you that any Hong Kong lawyer would be able to do it. Right. And I think do it as good as well as those lawyers that have been coming from US, Europe. We can all do it. There's no problem because we have our open jurisprudence available online. Anybody can download these episodes.
So it sounds like it's finding a common thread that link all the precedents.
That's right.
Yeah.
That's right. We apply principles of estoppel, for example, with no problem. We borrow from international law. Estoppel, of course, as you are aware, is one of the general principles of law that we have no problem applying. Good faith is another one. So we borrow from different ideas, and then we just basically to arrive at the right and fair and just outcome.
Right. Perhaps we should advocate more use in Hong Kong court. That would be exciting. So, yeah, not at all. So, any other questions from the floor? And yes, please.
At the moment, is as I understand it, there is actually nowhere that the athletes or the entities or the stakeholders can go in terms of an independent tribunal that can resolve these disputes. I think that is really I see the problem is, of course, as to the actual demands, how much of this demand is there. I think from the interest of the sporting body in our cross profession discussion group, I think there is demand, but I think the difficulty is how do we build, first of all, the trust in the system, because we have no experience of this kind of system in Hong Kong. In order to have a system that instills confidence, then we need the people who are experienced in doing it. So it really goes hand in hand. I mean, we need to improve awareness, first of all. We need to ascertain what demands there is, and then therefore to build a system that meets the demand. Initially, it may be a small system. It will not be a Hong Kong case. It will not be as big as that. I think we need to start small, and then we need to build the know-how, build the interest, and then we learn from foreign experience, even mainland and also other jurisdiction experience. And then once we have that, maybe we start with particular sport or particular just local dispute. We then go bigger and bigger, and then maybe we can then help to set up system that serves beyond Hong Kong. But I think my personal opinion is that we should start with Hong Kong level dispute. I think in China there is a big thing, as I've already explained just now, setting up the SAC. But for Hong Kong, there is no such thing at the moment. And whether the SAC might cover Hong Kong is still up in the discussion, or it's not quite certain yet. But I hope that the Joint Professional Group will really, Yang here, representative from the bar in Hong Kong, is very instrumental in pushing this forward. So please do feel free to speak to him after this a bit more. Maybe you can share a bit now. Yeah, would you like to?
Well, no, I wouldn't. The short answer is that I think actually Benny summarized it very well. There are steps up being taken to move things forward and make sure that Hong Kong as a whole can benefit from more consistent dispute resolution system. I think that's all I can say.
Is there any very, very rough timeline as to anything can happen, or is it really not really?
My personal hope is within the next year or so, you will see quite exciting developments. But that's just a personal hope.
Right.
I don't have to say more.
Understand.
Okay. So let's hope next year, before I retire, let's hope so. But anyway, so any more questions? Yes.
Now for yes, the context of my talk about HKIArb was in the context of basketball arbitral tribunal. So we, under our arbitral rules, specified HKIArb is what we will apply. So the underlying rationale and idea was we want to break down the jurisdictional barrier for different, because of course clubs, basically to tell the truth, bats deal with cases. We don't deal with NBA disputes. NBA, they have their own system in the States. But apart from NBA, I mean, we have also mainly is European clubs. We have Turkey, Russian even. We even have had some Chinese club disputes with the player. I mean, they don't come to me, they go to my colleagues. But so we want to break down these jurisdictional barriers so that we go in English, we go by these, well, HKIArb bono, fairness, and what is fair and right. So that really makes it easier for, encourages the parties from different jurisdictions to bring the case for dispute resolution, just as many other measures, low cost, fast, we want to encourage. And to give you an idea, each year, BAT has about 180 cases that was filed, 180. So we had 8 arbitrators before, and recently we have added 1 more. So if you think about it, we have about 20 cases each year. I mean, some of them will get settled halfway or even very soon after filing, but many of them will go to a final award. So so it is a good statistics that we see. Yeah,
of course.
So,
it's like inviting the senior wise men of the village, Chinjam. But of course, I mean, it really wise and based on a lot of precedents as well.
yeah, it is. Yes.
Yes,
Please.
gentlemen at the back.
Particularly, most of the countries who are doing sport, their jurisdiction are not equipped for sport.
Yes.
Right, yeah.
Yes.
So that's why they
I mean,
using this
the dispute,
procedure?
the dispute that we deal with are contractual disputes and financial in nature. In most of it. So it's not regulatory or doping, that kind of dispute. So for those regulatory and doping dispute, there are very specific codes, such as the WADA code for doping dispute. For other regulatory, you look at the sporting organizations' own internal regulations, for example, or FIBA. I mean, FIBA has its own regulatory dispute resolution mechanism. For example, if a player wants to go to another club, having terminated the contract, but the club will not issue what we call the letter of clearance to them, so that they can get registered again under another club. They bring the dispute to FIBA. They have their own system. So that is different type of dispute from those that we deal with in BAT, which are a lot of it is employment dispute. We have a lot of employment dispute. We have agency dispute, so agent representing a player so that they can get introduced to a club, and then there's non-payment, and then also issue arising out of that kind. So therefore, I think because of its financial nature, it's more amenable, slightly more amenable to that ex-AO code, a bono system. Whereas for regulatory and disciplinary, of course, you cannot, by its nature, you cannot apply that. So I see I sometimes wish that I can see more Hong Kong lawyers representing the players, but then due to the geographical nature, many of these players from US, from Europe, some of them from Russia, it's difficult for Hong Kong lawyers, for example, to get involved.
How often in the past
Very often.
Very often.
Very often. Yes, very often are legally represented.
Okay, so it's not a case where you encourage them to go to like small claims tribunal and have law.
They can. I mean, there are specialist sports lawyers, sports law firms. Some of them from Switzerland, of course, understandably.
Right.
From Spain, from Croatia, Lithuania, up there with all sorts of lawyers. Yeah.
Good. So we are really thoroughly entertained, if not humbled, about what we've learned today. So another round, big applause for Dr. Low, please. Thank you. Well, thank you very much. So we'll see you again very soon in our next seminar, and thank you for joining us today. Thank you.
Thank you.